I'm Don Davis. I'm a securities lawyer. I've been doing it a long time, and this is a series of videos about the securities laws. And today we're going to talk about a trap. Did you know that one small mistake in your deal structure and you can go to jail for 99 years? That's right, 99 years in time for one small mistake? Man, that's pretty tough duty, right? Well, and I see this mistake over and over. I see some of the biggest law firms, and boutique law firms too, who practice securities law, advising their clients and missing this trap, the trap for the unwary. So we're going to talk about that today. I had a lunch this week with a client, and he showed me a private placement memorandum from a friend of his that had been self-done, admittedly, and it was a debenture offering. It was a debenture offering like a note. You know, notes, debentures, loaning of money with the expectation of a return and profit is a security. Some people think that's an exemption. Well, it's not. It's a security. So this was a debenture offering, fair enough. You could certainly do those with a private placement or a public offering, and we do a lot of them. But this particular debenture offering had an interesting wrinkle. If at the end of 4 months, after you'd invested your money while the offering was still continuing, you wanted your money back, the guy who was running this company was so confident, he said, we'll just give you your money back. We will refund the amount of your debenture. So you hold it for 4 months, you see how he does. He continues the offering over approximately a year. The offering was going to continue. Don't like the deal, you say, hey, give me my money back. What's wrong with that? What's wrong with that? Well, from the investor's perspective, I guess, nothing's wrong with that. But from this friend who was doing this deal, making this bond offering, this debenture offering, that's a ticket to jail. You heard me, a ticket to jail. And this was a self-done offering. I don't think he had the advice of a securities lawyer. But a few years ago, somebody else came to me. They had a note offering. And they had an interesting company. Their idea was that small investors ought to be able to participate and loan money in small businesses, just like GMAC or any big lender. So their deal was that you bought a note. And we know now that a note is also a security, subject to securities laws. So that you would buy a note, and you would get interest paid every month on the note. And that continued that way. And of course, the offering continued as well. So he was offering these notes. You get on the note, you got your interest every month. You didn't have the right to get the note back for a period of time, but you got an interest paid out every time. And he came to me with this structure. He'd already raised about $10 million over a series of years in this. He'd had 3 law firms look at this particular prospectus, and they didn't have any problem with it. Again, the trap for the unwary. What is wrong with that? Why is there a problem in each of those deals? Well, you have to turn the tables here and think in the terms of a regulator. A regulator's perspective, be it the SEC or the Blue State Securities Law Commissioner of California or New York or Minnesota or wherever, they have a whole different attitude, a whole different perspective about the world. And guess what? They're not your friend. You may be the most honest person in the world. You may be trying to do the best deal in the world. You may have all the best intentions. You may use money in the best way. You may not have fancy cars or fancy lifestyle. You can count for every penny. Doesn't matter. Their job is to put people in jail. They're not your friend. So what's the matter with this? Well, it violates a tenet of the securities law. It's a situation where you're raising money in a private offering and simultaneously giving money back to investors in some form on some basis. In the first case, you could be raising money and also returning money on the debenture to folks who bought the debenture over 4 months. And the second one, you were returning money monthly in interest on the notes. What's the problem there? Well, from the regulator's perspective, that's what he likes to call a Ponzi scheme. Why a Ponzi scheme? Because you're taking money in from the investors and paying it out to the investors at the same time. So the money is fungible, it goes into a big pot, and it comes out, it washes. You're doing a simultaneous offering while you're taking some of the proceeds of that offering and paying off other investors. Classic Ponzi scheme, very difficult for a securities lawyer to defend against. And my client of some years ago, who I couldn't help because it was too late, he went to jail for 99 years. So very difficult trap for the unwary. Got to be careful. So the upshot is, even the best securities law firm sometimes makes a mistake. You got to be very careful. You go to for advice. You're very foolish if you don't go to advice before you start raising money from investors. And I'm here to help. Don Davis, securities lawyer. I'd love to hear about your deal.